Good morning. Happy Wednesday. I saw a video, a short snippet of a longer portion of one of Chilli's live streams where Chilli was essentially saying that he knows more than a Supreme Court justice about what probable cause is and what it isn't. He also said that essentially probable cause means you only have probable cause if the person actually committed the crime. The hint on that should be the name probable cause, not absolute certainty cause, but probable cause. That it only means that you need to know that the person probably committed, or that a crime was probably committed, and that the person who you're arresting probably committed the crime. But moreover, it shows a very limited understanding of what probable cause actually is, because there are multiple circumstances where probable cause needs to be shown. For example, in a grand jury proceeding, what the standard of proof is, what the district attorney or U.S. attorney or assistant district attorney or assistant U.S. attorney or whoever the prosecuting attorney is, what they have to show to the grand jury is that a crime was probably committed and that you probably committed it. That's the standard. It's probable cause. If the grand jury returns a true bill or whatever the local custom is for what they call it, if they return back an indictment saying that, the grand jury finds that this person committed a crime, what they're saying is probable cause. They're saying that this person probably committed the crime or a crime was probably committed and this person probably committed it. And so then that's why you then go to the court and you actually have a trial, because the grand jury isn't convicting you. They're not saying that we're finding beyond a reasonable doubt that a crime was committed and that you committed it. What they're saying is that we find that a crime was probably committed and you probably committed it. And then you get your whole due process thing where the state has to prove beyond a reasonable doubt that you committed the crime. So that's one way that it's used. Another way that's used, that is what Chilli is thinking about, is when a police officer thinks that you've committed a crime. If the police officer has probable cause that a crime was committed and that you committed it, he can arrest you, right? That's the minimum. And what probable cause is based on is what the officer knows at that point. So if the officer obviously doesn't know everything, we can't expect cops to be omniscient. We can't expect judges or jurors or lawyers to be omniscient. The cop only knows the things that he knows at that time. Cop walks into a room, sees a man standing with a gun in his hand over the body of someone who has just apparently been shot. Well, the cop has probable cause that guy killed the other guy, right? Probable cause. The cop doesn't know whether or not it was self-defense. The cop doesn't know whether or not the guy with the gun in his hand found the scene and picked up the gun to secure the weapon, not thinking about contaminating a crime scene, but he didn't actually shoot. The cop doesn't know any of that. The cop only knows what the cop knows at the time, and probable cause is judged based on what the cop knows at the time. So if the arrest is made without a indictment, without an arrest warrant, without something like that, then there is going to be a probable cause hearing. Your state might call it something different. California just calls it a probable cause hearing, where you go in front of the judge and the prosecutor basically lays out their case. And the judge at that point will make a determination whether or not there is probable cause to proceed with this particular case. That's not saying you're guilty. The judge isn't making a finding that you committed the crime at that point. The judge is only making a finding that, based on the evidence that's been presented at the probable cause hearing, that a crime was probably committed and you probably committed it. Specifically, the crime that you're being charged with was probably committed and that you probably committed it. That's all the judge is finding at that point. Another situation where probable cause comes into play, I mentioned arrest warrants. That's where the cops go to a judge and say, here's the crime that we think was probably committed, and here's who we think probably committed it. Judge, can we get an arrest warrant for this guy? That's the judge isn't saying when he signs that arrest warrant, he's not saying that guy definitely did it. He's saying that a crime was probably committed and this guy probably committed it. But another instance where a warrant issues is a search warrant. In a search warrant, obviously, we're not saying that the thing that they're looking for committed a crime. What we're saying is, what the judge is saying, the judge who signs the search warrant, is the judge is saying that based on the facts presented, on the affidavits presented to him, assuming that the things in there are true, that reasonably can be considered to be true. I mean, obviously, if one of the affidavits says the sky is green, well, the judge doesn't have to, okay, I'm not going to issue the search warrant because you said the sky is green. I'm going to wait till I get someone who's going to say the sky is blue, right? But the judge is going to assume that the facts alleged in the affidavit are true if they can reasonably construed to be true. And if the facts alleged in the affidavit sufficiently allege that a crime was probably committed, that this person probably committed it, and evidence is going to be found in this location of the crime, probably evidence. They haven't gone in there yet. They don't know yet. They haven't actually conducted the search yet, hopefully. So they don't know what they're going to find there. They say, I have probable cause to suspect I'm going to find the murder weapon there, the drugs there, the what have you there. So that's what probable cause is. Probable. And the reason why it's so nebulous is because the courts have never put like a percentage of certainty on it. The Supreme Court has refused to place that certainty on it. And it's because of that, there's going to be those gray area cases where one court might say, yeah, there was probable cause, and another court might say, no, there's not probable cause. And why can they do it? Well, because it's a nebulous kind of thing. Going back to my example of the cop walking in, seeing a man with a gun in his hand, standing over the body of another man who's just been shot. Would a court find that based on just that knowledge, that there's probable cause to make the arrest? Probably. But could a court say that, no, there's not enough? Well, we don't know. The officer didn't know. The officer doesn't say that he heard the gunshot. The officer doesn't say he saw a smoking gun. The officer can't testify to how long the body's been lying there. He didn't testify to whether or not there was the smell of a dead body. He didn't testify to any of that. He just said, dead body, gunshot, man standing over it with a gun in his hand. So two courts might come to two totally different opinions on whether or not the officer had probable cause to make the arrest at that point. That's why it's nebulous. And it doesn't, I understand that Chilli wants a bright line rule. Every cop in the country would love a bright line rule. Every lawyer in the country would love a bright line rule. Every judge would love a bright line rule, a rule that says, if X, then Y, right? Where it's just clear. You don't have to kind of, sort of, I mean, is this enough? Maybe not. I don't know. Everybody would love that. But the problem is that reality exists, and we live in a world where people don't know things with absolute certainty. We live in a world where people aren't omniscient. We live in a world where appearances can be deceiving. So we have to accept that, and we have to try to make our best judgment on what is or isn't probable cause and go from there. And it's a very low standard. Probable cause can be something like, if you said, oh, hey, I got a radio call that someone in a blue car was shooting outside of the gas station, right? Great. So you go down to that area and you see a blue car. Do you have probable cause at that point to arrest the driver? Probably not, right? Reasonable suspicion to stop him, maybe. But what if you get a report that says it was a blue 2009 Kia del Sol with a missing passenger side mirror, and it was being driven by two Asian women, or be driven by an Asian woman with an Asian woman passenger in it. Well, if the cop sees a vehicle matching that description, like exactly matching that description, does he have a probable cause at that point? Well, I mean, it's a lot better than just saying a blue car, right? It's a lot better. But what if he sees a green Kia Del Sol that everything else matches? Does he still have a problem? I mean, it's just one of those things. It's nebulous. That's all I'm going to say. It's really hard to put your finger on. And I remember a lot of time was spent in law school with students asking a lot of questions about like, well, how can you really fucking tell? And the professor was like, well, it's really up to the judge. It's just up to the judge. It's not a guess. It's not a possibility. It's a probability. Is it going to snow today in Sacramento, California? Well, it's possible. It is theoretically possible. It's not probable. You know, it's kind of one of those things. So anyway, I hope this helps. Probable cause, you could tell it doesn't require certainty because of the name, probable cause. And Chilli is once again showing his ignorance. A 20-year quote, 20-year constitutional law scholar, end quote, does not have a better understanding of probable cause than a Supreme Court justice. Even a bad Supreme Court justice is going to have a better understanding of probable cause than Chilli DeCastro. Thanks for watching. Have a great day.